Welcome to The Explainer. Today, we're diving straight into the fascinating and honestly often misunderstood legal realities of modifying an alimony or child support agreement down in Mexico. Listen, if you've ever wondered how the law handles the completely unpredictable nature of real life, where incomes go up and down and family needs are literally constantly evolving, you are in exactly the right place. We're going to unpack the formal legal dossier that dictates exactly how these absolutely crucial family support systems are adjusted over time. Okay, let's dive right into this roadmap. First, we'll look at what alimony actually is. Second, needs versus possibilities. Third, the risk of private agreements. Fourth, legal adjustments and the NCPI. And finally, the consequences of noncompliance. This is going to demystify exactly how the law maintains a dynamic equilibrium when financial realities change. Section 1. What is alimony? The basic concept. So, to understand how to change an agreement, we really need to grasp the baseline legal concept of what these family support payments, known legally as alimentos, actually mean. According to the dossier, alimento consists of benefits one person is legally obligated to give another, usually because they're related. The law uses three big words here: unrenounceable, non-transferable, and reciprocal. Basically, you can't waive your right to them, and you can't hand that right over to someone else. But that third word, reciprocal, that's truly fascinating. It means that while the obligation usually starts with parents supporting their kids, with time, that exact same legal obligation can flip. Kids might end up having to support their aging parents. The law absolutely recognizes that life is a long timeline. Section 2. Needs versus possibilities, the golden rule. And this brilliantly illustrates the absolute core philosophy of Mexican family law, which is relativity. Support amounts aren't just fixed in a vacuum. It's an ongoing balance between the needs of the receiver and the financial possibilities of the payer. It's literally like a dynamic, ever-shifting scale. Because it's relative, the law inherently knows that the obligation has to be able to change over time. If the receiver suddenly needs more or the payer loses some income, well, the scale tips and the legal obligation has to be adjusted to reflect that new reality. Section 3. The risk of the private agreement, the informal trap. Now, I want you to ask yourself this. What happens when circumstances change? When that dynamic scale we just talked about gets thrown way out of balance? We all know life happens. Kids grow up, inflation hits the grocery store, jobs get lost. The temptation for a lot of ex-partners or family members is to just sit down at the kitchen table, talk it out, and agree with a handshake to pay a little more or less next month. I mean, it feels like common sense, right? Why get the courts involved if you can just handle it privately? So, the crucial point is this exact warning from the legal dossier. A private agreement that modifies the amounts is not sufficient and usually brings more problems than solutions. Trying to fix support amounts with a handshake, that brings massive legal trouble. The law dictates that any modification has to be verified following the exact same formal procedure used when the alimony was originally set. A private side deal does not legally overwrite a court order. If you just start paying less because of a quick text message agreement, in the eyes of the law, you're literally accumulating debt and breaching a formal obligation. You've got to go before the proper jurisdictional authority to formalize the whole shebang. Section 4. Legal adjustments and the NCPI. The mechanisms of the law. Well, if kitchen table agreements are a trap, what's the right way to fix the scale? Article 311 of the Civil Code actually builds a proactive adjustment right into the system. It says that whether the alimony came from an agreement or a judge's sentence, it legally must have an automatic minimum annual increase. You don't even have to go back to court for this baseline bump. It's baked right into the original order to protect the receiver's purchasing power. Now, what's really interesting about this calculation is how strictly it's tied to the annual percentage increase of the NCPI, the National Consumer Price Index. Basically, it's tied to inflation. But there is a vital safety valve for the pair. If the debtor can legally prove that their actual real-world income didn't go up by the inflation rate, then the alimony increase is adjusted only to the actual percentage their income increased. But remember, these conditions always have to be formally expressed in the sentence or the agreement. No handshakes. But what about the bigger changes? Not just inflation, but maybe losing a job or a child having a new medical need. Cutting through all the legal jargon, Articles 178 and 567 make it crystal clear. Firm judicial resolutions regarding alimony are not carved in stone forever. They can be formally altered when the circumstances change. The law says these issues will be decided via an incidental proceeding and reviewed in a preliminary hearing by a judge. So if you want a modification, you actually have two precise legal avenues to get it done properly. Avenue 1 is the incidental proceeding. Think of this as opening a mini trial inside the original existing legal file. Avenue 2 is an autonomous trial, which is just a completely new independent procedure. Either way, the judge is the one who ultimately decrees the change, either by approving a new agreement you both submit or by judging for themselves based on the evidence. Finally, Section 5, Consequences of Noncompliance. What does that state? We know the rules now, but what if someone just ignores all of this? The system is designed to act fast. Under Article 568, once a judge decrees the alimony, it's communicated without delay to whoever pays the debtor's income. In other words, your employer is immediately brought into the loop by the court. The enforcement is embedded right at the source of your income. But here is the real punch. If you decide to just stop paying, or even if you only pay a partial amount because of some informal private agreement the court doesn't know about, the judge has a wildly strict legal window to act. 3 days, just 72 hours. Let's see how this builds into real-world consequences. Under Article 568, if the authority verifies total or even just partial noncompliance, whether it's ordinary or retroactive alimony, they're informing the authorities within that 3-day window. The result? The non-payer is officially and immediately added to the National Registry of Alimony Debtors. And listen, this isn't just a slap on the wrist. Being on this public registry can severely impact your credit, your ability to handle legal and financial procedures, and your overall legal standing. It is a big deal. So, as you'll see, the law treats family support not as some static, rigid number, but as a dynamic equilibrium, constantly balancing needs and possibilities. But the absolute key takeaway is that maintaining this balance requires formal legal action, for sure, not casual agreements. So I'm going to leave you with this. If your financial life completely changes tomorrow, will you let the scale break and risk those massive consequences, or will you use the precise mechanisms of the law to maintain the balance? Think about it. Thanks for joining me on The Explainer.